I want to talk about an area of law that my firm handles, and these cases involve physical attacks in a commercial establishment, such as an apartment complex, a mall, or any other business due to inadequate security. Now, Georgia law requires owners of properties and businesses to protect their customers and their tenants from unreasonable dangers. These individuals and these companies are required to take minimum steps to learn of dangerous conditions and to correct these dangers so their customers or their tenants leasing their apartments are not hurt. But when these businesses do not take reasonable steps to correct the unsafe condition and someone is seriously injured or killed, there is a potential claim for inadequate security. Let me stress one important point though. Just because someone is injured on someone's property does not mean the property owner or business is at fault. We must prove, one, the business owner had prior knowledge of the hazard or the danger, or with the exercise of reasonable care should have discovered it, and two, the business owner did not take reasonable steps to correct the hazard or prevent the injury from occurring. And it seems that every time you turn on the news, you hear about someone being sexually assaulted in their apartment or in the parking lot of their apartment complex. And these reports are very disturbing. What's more disturbing is that if the apartment complex had exercised reasonable care, a lot of these crimes could have been prevented. They never would have occurred. So when these attacks occur, we typically find one or two things have happened. One, the attacker is a resident at the apartment complex or is a guest of the resident. Or two, the attacker came onto the apartment complex grounds as a trespasser. Now let's address each one of these in more detail. If the attacker actually lived at the apartment complex, it's a challenge for us to show that increased security measures could have kept the attack from happening. This requires a lot of investigative work. Could the apartment complex have screened the tenant better by doing a criminal background check on him? And if he came up with a criminal history, could they have rejected him as a tenant? Were there burned out or broken lights in the parking lot or breezeway that were not replaced or repaired that provided the cover of darkness for the attacker? How long were these lights out, and was the apartment complex on notice? Is the parking lot fenced, or is the fence broken or cut in areas that allow both the entry and the escape for the criminal attackers? And let's look inside the tenant's apartment. Are the locks on the doors and the windows inadequate or broken, allowing easy access for the criminal attackers? Now, let's look at when the attacker is a trespasser on the apartment property. Our investigation focuses on two things in these types of attacks. One, we need to discover if other attacks, other sexual assaults, or other violent crimes have occurred on the property before the attack we are investigating. And two, we must find evidence to show the apartment complex did not implement the reasonable necessary safety measures to protect its tenants after these crimes and attacks started to happen. And the courts have told us that prior property crimes may give a landlord notice of future crimes, possible crimes against a person. All right. So with all this said, here are 5 ways that we try to provide the defendant business owner, or prove rather the defendant business owner was negligent in protecting people on his property. 1, prior crimes. We start by securing the crime reports from the local police departments through an open records request. And if there are prior violent crime or criminal attacks at the apartment complex, previous robberies, shootings, or sexual assaults, then the apartment complex is constructively on notice a serious security problem on their premises exists. 2, the defendant business owner's internal reports. We want to see if the defendant apartment complex had any internal reports which identified prior crimes in the area. 3, what security practices are already in place. Another thing we investigate is what security practices the apartment complex has in place to protect the people that are invited onto its property. And 4, prior victims. We may also interview prior victims of similar crimes at the apartment complex or in the area. And these are especially helpful if the crime occurred at the same location, which shows the landlord knew of the prior incidents. And 5, security experts. There are times where we may hire a security expert to help us establish that the apartment complex breached the standard of care by not having security when needed or by having an inadequate amount of security. So as you can see, the handling of a premises liability inadequate security case can be a challenging effort, and they're very expensive to pursue. You need an attorney that is experienced in these types of cases. So if you or a family member have been the victim of a sexual assault in an apartment complex or the victim of a violent crime, I encourage you to call us right away for your free consultation. It's confidential. There is no obligation, and the inquiry is free. And if you'd like to speak with me, with my law firm about your claim, we make it very easy for you. Just pick up the phone and give me a call right now, 1-800-WIN-WIN-1. And to learn more about me and my law firm, you can visit GaryMartinHayes.com. Or one other thing you can check out on our website, my law firm was featured on the Biography channel. It was a great documentary entitled Stand and Serve. So you can learn more, again, about me, about the attorneys and the staff that work with me. Again, pick up the phone, call us. Do not delay, because evidence can be lost. Witnesses can forget what happened. Let us help you. 1-800-WIN-WIN-1. Give us a call right now.